Number one, we're finished. We're there. Yeah. There's my way. That's as normal as I can get. This is the Texas. This is what happens in Texas. This is custodial. What it can Miranda violations be fruit of the poisonous tree? And to some extent, the Supreme Court has said, Missouri versus Siebert, in your materials, they said that too often what you have are cases where there was a standard operating procedure, an SOP, where the police officer would take an unmirandized confession, then follow it with a Mirandized confession. They say, you can't do that. That taints the subsequent Miranda, the Mirandized confession. In Patain, it's derivative evidence. They say, well, you know, what'd you do with the gun? The guy tells them where the gun is. These derivative cases are a little tougher. And what the Supreme Court says, the Fifth Amendment, this goes back to the Hudson rationale. What's the Fifth Amendment designed to protect against? Compelled testimony. And the gun ain't testimonial, it's physical evidence. So the Supreme Court says, no, the core of the Fifth Amendment protection is testimonial. Physical evidence is not protected by the fruit of the poisonous tree. Again, like Hudson, you look to the particular interest protected, and testimony is all. This is, in conclusion, this is a case we had in Texas, a fight. They had 40, this was a compound, they called it, a home in a gated community. They drove personnel carriers through the front gate of this place. 40 to 50 guys, all in black with masks. They rammed the front gate. They threw out explosive devices all around to scare everybody there. They put grappling hooks, pulled the front door and all the windows out of the house. And then the officers had the defendant nude from the waist down with a shotgun over him when they interrogated him at gunpoint. And the Fifth Circuit said that that was not custodial for Miranda purposes. Now, by the way, this is my client. You can barely see the gun up here, but this is, you know, that's his nude butt. He's laying face down. You know, I mean, I don't get it. I mean, guns, tanks, explosives aside, where's a guy, a naked guy, gonna go? You know, I think his freedom of movement was adequately restricted. The last one is the Texas Court of Criminal Appeals last term. I mean, this is a classic. They held in Herrera versus State that this is hard to take. That in fact, you're gonna hibernate. I can just tell you about it. That in fact, sorry, dear. That in fact, imprisoned inmates in the Texas Department of Corrections are not in custody for Miranda purposes. And the reason they held that was, they said otherwise all imprisoned inmates would be in custody. Duh! Thank you all for enduring I expect every one of you all to be there tonight, 7 to 11, otherwise known as 7 to Forever. It's great food, good companionship, a lot of fun.